Into my code, like I could have stopped. Remove that this extension of my data.
Okay, good day everyone. Welcome to the fifth week of the fourth quarter of mentorship in the energy industry. Once again, I would like to apologize for starting class very late today. Sorry, it's not in our culture to do so, but we had a little difficulties doing that. But again, we sincerely apologize for the lateness in the start of class. So without wasting much of our time, we'll be going into our topic for today. Our topic is our topic for today is contracts, regulatory compliance, and disputes regulations. That is our topic for today. We've come all the way from the first week to the second week, where we talked about more general terms and knowledge as pertaining the energy industry, from fossil fuels to renewable energies to the power industry. Now we are in more legal terms, or we are in more the legal aspects of the energy industries, and we will just be going ahead with the introduction of our mentors for today. Our first mentor for today is Mr. Okeogene. Mr. Okeogene is no stranger to he has been here time and time again, joining us. Sorry, our second mentor for today is Mr. Alexander Olatunde Akulu. Mr. Alexander, we're also not strangers to Mr. Alexander. Mr. Alexander has been with us also from, I think, week 2, right? He has been here time and time again, helping us discuss topics as concerning the energy industry. You are welcome, Mr. Alexander. Thank you for joining us. Our next mentor for today is Mr. Okechukwu Kelly Agbo. Mr. Okechukwu Kelly Agbo has 15 years experience 15 years work experience in the oil and gas industry across the upstream, refining gas, and the power value chain. Welcome, Mr. Okechukwu Kelly Agbo. Our last but not least on our mentorship list is Miss Ehon. Sorry, ma, if I did not get the pronunciation of your name. I really do apologize. Miss Ehon Ho is a legal advisor in the energy sector. She currently works with Greenhouse International Limited, she's a former associate of Alex legal practitioner. She has an LLM from the University of Sussex and an MBA from the University of Warwick. Thank you, Ms. Agbo, for joining us. Thank you, Ms. Agbo, for joining us on call. We'll just go ahead and introduce our mentors for today. We'll just go ahead and have our mentors come give us their presentation for today. First, we'll be having Mr. Ayobami. Mr. Ayobami, thank you for joining us. Please, you can come and give us your discourse into today's topic: contracts, regulatory compliance, and disputes regulation, sir. Welcome, sir.
Yes, thank you, Dennis. And it's nice to be here week in, week out. And like you just rightly said, I mean, finally we have something that we lawyers can relate to. You know, it's been the engineers and the economists discussing for the last few weeks, And yeah, and it's always good as a lawyer to have a background knowledge of the technicalities of the sector you're in. You know, you, of course, over the years you build up a knack of it. And when I talk to my engineer friends about Mumpo Village, for example, they look at me like I'm not an engineer, but it's something I've picked over the years by being in industry over a decade and counting. Yeah. So when you talk about contract regulatory compliance and dispute resolution, this is now your core. I mean, this is what you do. It's either you're handling a contract or you're advising in compliance or regulatory compliance, or you're handling dispute resolution, you know, whether in-house or maybe in a law firm. So this is now the core of what you are as a lawyer, basically. Yeah, and it's quite important. And it gets me on the edge sometimes when they call lawyers support staff when it comes to energy. But the fact remains is that without lawyers in energy sector, I mean, how do you have transactions without a lawyer there? You know, so that's how important you are into it. Because from the beginning, you are involved, and throughout the project cycle, you are involved from the beginning. There has to be contracts, one form of contract or the other. You know, there are various types of contracts. Even within, you have vendors, subcontractors, suppliers, and so the procurement process, you still have to get involved. And of course, you have the regulatory arm whereby you have to liaise with the government agencies in a particular energy space. You know, if you're talking about power now, you know who to liaise with, the Electricity Commission, you know, they have NNPC, the former DPR, NURPs, you know, that's Nigeria Upstream Regulatory, and the downstream and midstream authority. So these are regulatory things. You need permits, you need licenses, and of course, when the contract goes wrong or business goes wrong, then you know that there's a dispute resolution, and you have to have the right dispute resolution mechanism, and of course have the best support you can give if you're in-house, the best support to your external counsel. And if you're an external counsel, of course, you know, you have to, you know, do well with your clients, basically. So I'll just run through each of them. You know, contract, like I said, there are various types of contracts, whether you are in the renewables or you're in the oil and gas or you're in the power. You know, in power, you heard of power purchase agreements, and Alexandra will be itching to talk more about those contracts, you know. And, you know, in the oil and gas, you know, you hear about the JVs, you hear about the farm in, farm out contracts and everything. Of course, you have service contracts, you know. Sorry, I think I heard someone. Okay, go ahead. I'm going ahead. Sorry. So there are various, you know, contracts you have to have in place, you know, and basically, in just the oil field alone, you can have. I mean, I remember I was once working on the project, and I had over 30 contractors on that project, you know. I mean, so you have to have service agreements with them, you have to have purchase agreements with them, you have to handle if it's offshore, you have to handle it will be the FPSO contractor that will give you an FPSO. There'll be the marine vessels, which you have to use BIMCO templates or something. They'll be using various types of templates and everything. You know, there's a drilling, there's the gas supply, you know. So in all, as a lawyer, you know, and you also, by the way, you also hear about contract engineers, and you also hear technical people getting involved in that. Yes, because, you know, it cut across just the T&Cs. The insurance people have to get involved. The taxes have to get involved. The finance part, because you might have financial securities in place, letter of credits, talk about bank guarantees, advanced payment guarantees, and everything. So there are lots of contracts involved, and you have to be sound in those contracts. So there are some, when it comes to contracting, there are various templates which has been recognized worldwide. You hear of the Logic templates, you hear of the FIDIC templates. If you're involved in the offshore maritime, you hear more of the BIMCO templates, which is Norwegian template accepted worldwide. You know, so there are various templates, but some companies also have gone ahead, because those templates usually are just there's a neutral templates for both the company and the contractor. So companies will tell you that no, they have to more like improve on those templates. So companies will have a template of their own that they use, and they use in negotiations. So that's where you start having you have to start building your negotiation skills, has to building your drafting skills. You have to know more about the sector, because if you know more about the sector, you'll be able to understand what those terms are. For example, I was working on a contract for some purchase of turbines, gas turbines for a power plant, and some days ago, and a word came: delivery, inspection on delivery. So the question I had to ask was, when will delivery take place? So is delivery going to take place since it's FLB, meaning that it's going to be picked up, even it's even X works actually. It's meaning that you pick it up at the manufacturing site. So do you say delivery occurred there, or do you say delivery is when the package arrives at your site? Because they expect that when it delivers, it's inspected. So when I go and pick it up in the workshop, most likely I don't have time to inspect it at that moment. So it's a whole lot. So you have to start defining provisional delivery, final delivery, and everything. So it's a whole lot. And if you don't know what entails, what goes on in that sector, you may not be able to understand and review the contract properly to the benefit of your clients. And a well-drafted contract in basically it's to minimize your risk. You try to anticipate it as much as possible. And I always tell people that some lawyers don't like litigation. They don't like getting their hands dirty. But I always say that spending a few early years in your career during litigation actually helps you to build your risk appetite. You'll be able to foresee some risks, so you'll be able to avoid them. So I'm always a strong advocate of spend a few years, get your hands dirty. I mean, I did a few years in practicing law in Nigeria and a law firm in the UK, in London, central London. So, I mean, before I crossed in-house fully. So, and honestly, I was actually employed because of my litigation background. So it's important that you get your hands dirty, because it helps to build you, it helps you to anticipate risks. And so there's some terms in contracts that you always want to keep an eye on, and when it talks about the warranty guarantees, the liabilities, the insurance, the correctional, so hopefully maybe we'll have more time to discuss it at during the section, or maybe most likely I give you slides on that so that you have those things on at your fingertips. And basically, so contracts is the bane of the existence of a project, and if you get it wrong at the beginning, then liabilities, as little as taxes plays a long way between your profit margin. Now, when you're into contract project management, figures are involved. So if, for example, you're in a maritime, it's an offshore maritime thing, you have to pay cabotage 2%, you have to pay VAT 7.5, you have to pay withholding tax. If it's if it's a service, it's more 5%. If it's a rental, you can pay as much as 10%, then, so if you don't count, sometimes you can have a tax of 13.5%. So if your profit is 10%, that means taxes are low as eroded the whole thing. So these are things that I say a lawyer must have a little bit of knowledge about everything: insurance, taxation, the engineering involved, the logistics involved in company procured items and everything. So it's a whole lot of contract. But yeah, you build this over the years. Yeah, but it's good for you to have a basic understanding why starting up. So when it comes to regulatory compliance now, I mean, that the sector of the energy sector over the last few years, as we have seen the Climate Change Act, we have seen the PIA, we have seen the Electricity Act that was signed into law this year and everything. So these are regulatory, and they have licenses, they have permits, and that you need to. So you need to get yourself enmeshed. I mean, get yourself grounded in those laws, because those laws interpret how you go about your regulatory compliance. And of course, there are always fines involved, and when you can even lose your license if you lose your ability to work in a particular sector if you don't have those particular licenses. And if you're a lawyer that's going to compliance, then you have to have the nice grasp of the law, and also have a way of monitoring the law. I used to use a software in the past, Nigerian software, and it gives me a prompt every 90 days before a license is supposed to expire, so that I can start early to put in an application for a renewal or something. And you have licenses, some in 6 months, some in 1 year, some in 2 years. Some it's a one-off in licenses and everything. So it's very important that you keep an eye on those licenses, and because they can umpire any operation you are in if you don't have those licenses. So at one time, I think I had over 100 licenses I was renewing, and I just had to keep a hand on everything. Yeah. Now, dispute resolution. On dispute resolution, it's quite important. Now, our laws, sometimes or most times, actually frown against having a foreign dispute resolution mechanism in place in your contracts. Yeah, but sometimes it's so difficult, especially if you're having a contract with a foreign entity, because they always want it to be situated outside Nigeria, or they want it in neutral ground. Now, for most Nigerian contracts, almost always been the laws. They call it the laws of the United Kingdom. But I have a bit of a concern against this, because the United Kingdom actually consists of England, Scotland, Wales, and Northern Ireland. So how do you now say law of United Kingdom? Which of the laws? I mean, and that gives room for forum shopping. Okay, now forum shopping is more like you go into the supermarket, and you have your ability to choose anything that's favorable to you. So, for example, now, if I think the law of Scotland is more favorable than the law of England, and it's under the laws of the United Kingdom, I'll go for law of Scotland, and another party might go to the law go to court in England. So they're giving room for options. I'm going to give room for options. You have multiple cases going on at different places. So it's good for it to be specific. Now, if it's the law of England, stick to the law of England. If possible, narrow it to the courts in London, so that England is also quite a wide number of courts everywhere. So have it strict away, clear, no ambiguity, and most people quote the law of England without even having an understanding of what the law of England says. That's another issue, and I mean, that's quite important, that's quite important that the law of England, you understand the law of England, and you know what the law says, basically, before you go into a particular contract at a particular time, So all these are very important, the dispute resolution body, the law governing, the rules governing it, and everything. These are things that you must know and have in place, before you go into a particular dispute resolution mechanism. So this is just an overview. I know that there'll be questions, and if possible, if I have time, I most likely make a slide on this, because I know that this, as lawyers, is quite important in making your career. Yeah. So thank you, guys. Yeah. Right.
Thank you so much, Mr. Ayobami. We really, really do appreciate if we could get a slide from you and share with our mentees. Okay, we'll be going on to the brief introduction of our next mentor. We'll be having Miss Obo. Miss Obo, this is her first time joining us. Thank you so much. Thank you so much, Ma, for being here. We really do appreciate your presence. Ma, please, you have 20 minutes for your presentation, your introduction, rather, as regards the topic for today. Thank you, Ma.
Okay, hi. Can you see me?
Yes, Ma, we can.
Okay, I want to share a moment. Can you see my screen?
Not yet. Okay, it's just started sharing.
Okay. Okay, so I just tried to put something together. I think was it Femi who spoke first? Sorry, I missed your name, because a lot of what I shared, or what I'm hoping to share, he's really touched on them. So I'll just try to go over it as quickly as possible. So thanks a lot to the JIIPC team for the opportunity to share. I don't work for Greenhouse Energy. I work for Green Energy. Yeah. So when I looked at the topic, it's quite broad, and I was just thinking, like, how much can we really cover? Because, like he shared, if you have to talk about contracts alone, I can talk about contracts for 3 weeks, 1 month, 1 year, and we're probably still looking at a single contract. And then we're looking also at regulatory compliance and part of the details I'll look at it in the slides is just about how the sector is really overregulated. Like, just think about any government agency, and you will get a letter from them saying, oh, your company has contravened this particular law. We are entitled to regulate this particular section of your business, and you're dealing with so many regulators. Yeah, so regulatory compliance is also a huge part of what we do, especially as in-house counsel. I work as in-house counsel. And then you talk about dispute resolution. Again, that's also something that I would agree with the first speaker as well when he spoke about first starting off your career working in a law firm. I started my career working in a law firm, Alex, and I did more litigation, commercial litigation, and I agree that it is totally essential because, of course, after a while, litigation got boring for me, really, because I got tired of going to court every day, taking adjournments and doing all that. But just the idea of how, a simple thing you fail to do can cascade into this big dispute, that you take to the High Court, the Court of Appeal, the Supreme Court, and just all the work that goes into preparing those briefs, presenting those arguments, and understanding the flow is something that's valuable to you, or that would be valuable to you as in-house counsel. So that's also important. And then we'll talk about all these things and how, how they can be useful to us. So just by way of overview, the energy sector is really broad, really, really broad. So you have fossil fuels sector or subsector dealing with like oil and gas. Oil and gas, you look at the upstream, which is like exploration and production. You look at the midstream, talking about things, around like storage, building your terminals, transportation, still of crude. Then you move downstream, and then you're talking about refining, refining these products. That's where you have things like maybe people who operate or companies that operate like filling stations. They operate in the downstream sector, the storage of these refined products, the transportation, the marketing of these refined products. All this is just on the fossil fuel or oil and gas. Of course, if you want to go technical, fossil fuel is it's broader than just oil and gas, but I'll just limit that to oil and gas. Then you look at electricity power. You look at the people who are operating in that space, the GenCos, generating companies, the DISCOs, distribution companies, and the embed. There are so many players that help to ensure that the electricity sector works, and whether that sector works is something that we can all we can all give a verdict on one way or the other. Yeah, but there's a whole mechanism, to make sure that that sector works. Then you look at renewables, alternative energy. We're in the energy transition era, so there's a lot of discussion about renewable energy. I work in oil and gas, and so the issue about sustainability and is an issue that we're having discussions about. But this is also important when you're talking about certain kind of contracts that you would have to negotiate or review in the oil and gas sector, because the issue around sustainability is a key concern. And then nuclear energy. So that's just an overview of the energy sector. Then to go into energy contracts, or I would look at mostly oil and gas contracts because that's where I have more specialty in. So I try to look at it from end to end. Before you start the business, how do you get into the oil and gas business? You don't just, have a conversation with your friend, over coffee or whatever, and the person just signs an agreement. Oh, I give you this asset. It doesn't work like that. Like the first speaker said, there are some standard templates, that have been recognized, or the people have used, companies have used over time, and so or that regulators have designed. Like, for example, under the PIA, that's the Petroleum Industry Act, that we're operating now, the current regulator, the NUPRC, Nigeria Upstream Regulatory Commission, they've designed their own concession contracts, the general conditions, lease conditions for whether the PML, which is petroleum mining lease license, or the PPL, the petroleum prospecting license, depending on what license you have, they have their own standard terms and conditions. And these terms and conditions, when they first issued them, we had like multiple stakeholder meetings, interactions, negotiations. But at the end of the day, the regulator will tell you, this is not a contract. This is a regulatory contract. So, and they say that because the terms of that contract are largely influenced by the law, by the act, the PIA. So there might be certain terms that from a commercial perspective, the company might say, oh, I don't like this. I want to be able to, or it's not commercially feasible, for example, for me to give you a performance bond for my work program of maybe $20 million or $100 million. The cost of that bond is high. And then that money, for example, if it costs me $1 million to get that wouldn't happen. But if it cost me $1 million to get like a $50 million performance bond, that's money I could use to actually develop the assets. So there could be conversations like that, but the regulator will say, notwithstanding this commercial argument you've presented, which is valid, there is a clear provision in the PIA for you to provide this security for the work program that you're saying you're going to execute or implement. So that's just an example of how, these contracts work. But apart from concession contracts, we have production sharing contracts. But currently, unless you're coming into unless you're talking about existing arrangements, the new way you can get into oil and gas assets will be concession contracts. Then he also spoke about participation agreements. We came in through a farm out arrangement. Our company came in through a farm out arrangement under the marginal field regime at the time. So we no longer have marginal fields, but at the time, where a particular asset or a field might not be economically viable for a big IOC like Shell, because the costs of developing that asset over the returns or the recoverable volumes and the profit they could get from that particular asset it will make sense. But it would make sense for a small company that has like a low cost operation. It would make more sense. So some of those fields were farmed out. So that was where we had farm out agreements, where those, small parts of those big OMLs at the time were given to marginal field operators. We also had a farming arrangement where we then had the asset, and then we had 100% interest in that asset, but we couldn't develop the asset ourselves. So we had someone like a financial partner farm into that asset, carry the cost during development stage, and then during production there was cost recovery and all that. So those are participation arrangements that parties might have at the asset acquisition stage. Then he's also spoken about service contracts. If you don't want to go through the hassle of getting equity participation or actually holding an interest in the asset, you can just provide service, and you could get paid in cash or kind, depending on what you agree. But most times people would prefer to be paid in crude. So some people will get paid in crude, or some people will get paid in cash. So you could have financial and technical services agreement, different service agreement, general service agreement. And then depending on the structure, the parties decide to use whether an incorporated joint venture or an unincorporated joint venture. We had an unincorporated joint venture, so we still had separate companies participating in a particular asset, but some other companies would opt to form an independent company that would then be the SPV or the asset company for that particular asset. So you would need a shareholders contract as well to manage that relationship. So these are just some of the contracts that you would need to walk through when you're at the asset acquisition stage. When you've now gotten the assets, you have so many people sitting on assets, they're not developing the assets. That's not good enough. But when you decide, maybe you've raised funds, you've got a financial partner, or you've raised funds from the bank, and you want to actually get this asset to production, because at the end of the day, that's what is important, getting the asset to production. You then enter into different kinds of contracts, still service contracts for your 3D seismic, geological studies, and all that. You would also do drilling and well completion contracts. On this drilling and well completion, I will just say a word, because again, the first speaker talked about how on a particular project you can have 30 different contractors. At this drilling stage, it is normal to have multiple contractors, subcontractors on your side. But one strategy that we've adopted to make things, in terms from a project management perspective, to make things work, is to have a turnkey. So the last 2 drilling campaigns we've had, we did a turnkey. So we got one contractor, for example, like a baker, and we're like, everything, well completion, drilling. Of course, the contractor would then have to work with a particular drilling contractor, but all those multiple services that come with, drilling and well completion, we would hold you accountable, and then we have a turnkey, we lock in the price for the well, we lock in the services, the scope of work, and we just ask the contractor, deliver my well to me in maybe 50 days or 60 days, and there will be no variation, there will be nothing, So we've just come up with creative ways to make sure that, or we can come up with creative ways to make sure that we manage, multiple contractor interface issues. Then you have still a development stage, you've drilled your wells, you then need to have facilities for your storage, for your processing. So that's where you have like engineering, procurement, construction, installation. They come in depending on the scope of work that you agree with the contractor. You could have one contractor do the engineering. You could have another contractor do engineering, procurement, and construction. You can have another contractor do installation and commissioning support. You can have another contractor include that with management, or the operations of the facility. So it just depends on the scope. But again, just like we did with the drilling and well completion contract, I would always advocate for a single contractor, because interface issues, they create a lot of conflict, and you have a lot of disputes arising from, it was this contractor's scope and this contractor didn't do what he was meant to do, at the time he was meant to do it, and it impacted this contractor. And then you have schedule slippage, cost overruns, and all that. So I would always, advocate for like a general wholesome turnkey strategy where it's usually more expensive. It's usually more expensive, but in the long run, it will save you a lot of stress. I'm speaking from it will save you a lot of stress. And then you could have your operations and management when you now have your facility, your production facilities, your pipelines, your storage facilities, depending on, the development plan that you have for that particular asset. You may not want to hire your own staff to operate the facility. Our company, what we did was the EPC contractor, we also give the EPC contractor an O&M, that's an operation and management contract, for like a year. And during that year, we had some of our staff.
At this stage, are still falling.
Sorry?
Sorry, I was just a small background noise. Sorry about that.
Oh, okay, sorry, I thought it was a question. Okay. Yeah. So you can have your operations and management contractor. You can have your staff understudy the operations and management contractor, and then towards maybe after for example, if we started off with 20 O&M staff, every quarter we would let 2 go, and then we would put in our team members. So there are just different ways you can structure these contracts to make sure that, your overall, operation philosophy for the company, whatever works. Some companies don't want their staff to be on the field. Some companies use like operations and management contractors, and that's fine. Then you have your transportation and storage contracts, you have your crude handling contracts. Those are very important contracts. I think another contract I didn't put here has to do with like your sale contract, your offtake contract, the person who purchases your crude. Of course, there are some regulatory issues as well around domestic crude oil supply obligations, where the government will say, rather than you selling your crude to like an offshore shell company or whatever, they would want you to, for example, don't quote me anywhere, sell to maybe a Dangote or some other Nigerian refinery operator, so that those people can have like feedstock for their refinery and all that. But that crude offtake agreement, the person you're selling your crude to, is a very, very important and it's a very strategic contract, because when you're thinking about future field development, future asset development, your crude offtaker would usually be, at least in our experience, one of your first ports, to say, oh, can you give me money for this project I want to do? Can you give me? So if your offtake contract is not well structured, it might impact, how much you can get from your offtaker, the terms and conditions for such offtaker finance as well. So that's just generally the different kinds of contracts we can have in the oil and gas sector, from the asset acquisition stage to the development stage to the production stage and then to the export. So there are different, this is just like very, very broad, but there are different contracts that you will get across the entire value chain. And again, it's not like you have to type or prepare this contract from beginning to the end. There are many standard templates. You can take them, adopt them, refine them, tweak them here and there to make sure that it suits, your operation or your objective. Again, the last speaker talked about risk allocation and risk mitigation and risk. I feel like the real objective for having a contract is to allocate risk. Because when you're having a conversation with the contractor, everything is cool, everything is calm. But when there's a problem, that's when you understand the importance of getting your contract right. So your risk allocation, every portion of that contract is risk allocation. Who bears responsibility for what? Who takes responsibility for what? What does that person take responsibility? So some of the key issues, there are so many, but the ones I've just listed here: dispute resolution, because disputes would usually arise. I work for a company where the general philosophy is to engage. We do not really want to like go to court or take these things to arbitration, because we realize that it costs a lot of time, costs a lot of money, and of course you lose valuable relationships when you have to go through the entire dispute resolution process. Usually it doesn't work. And I've also discovered that sometimes if parties can just sit down, at the table and look at the interest and see, what concessions can be made, you're more likely to resolve, whatever issue you have, than going like a full-blown litigation. Of course, the mechanism for this discussion or this negotiation is also dispute resolution. So it's important. We usually build in these like prior discussions into our contracts to make sure that when there's a dispute, somebody doesn't just go to the Federal High Court, gets one ex parte injunction, disrupt our operations and all that. So it's very important you get your dispute resolution right. Termination and suspension clauses. Termination clauses are very important. You want to get into a contract, you need to know where the exit door is, because different things could happen and you want to get out. Limitation of liability. I think limitation of liability is something that is more important to the contractor than the company. Because, for example, if I get a contractor to drill a well for me, I might pay the contractor maybe $30 million, for example. But if that contractor destroys that well, that contractor might be losing me maybe $200 million. I can't tell. And in fact, if it now becomes an environmental damage issue, we might be talking billions of dollars. But the contractor will tell you, how much are you paying me? What's my, balance sheet, or what's my asset base? How much do I have? I can't take on that kind of liability, even if I'm at fault. So the contractor will usually say, no, I will cap my liability under this contract at maybe at best 100% of the contract value. Some contractors will even negotiate down to like maybe 30% or 10% or 20%, one way or the other. But insurance is another way a company can manage those risks. So that's why I say contracting is about risk allocation. When you realize that, oh, you're exposed in this particular area, then you get insurance to, you know, mitigate your exposure in that area. I don't know if I still have a lot of time, but there are also local content issues. Nigeria is very big on local content. The NCDMB, Nigerian Content Monitoring Development Board, Development and Monitoring Board, sorry. They are very, 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 very keen on development. And the law provides that you need to give Nigerian companies first call on, you know, certain kinds of contracts. If you cannot get it in-house or in-country, then you then need to provide some justification for, you know, going abroad to source for those services or source for those products. So local content is a very key critical issue. Local content in terms of your management. I work for 100% Nigerian company, so we don't really have issues around local content with in terms of management staff. Every staff of our company is a Nigerian. But for a lot of companies, especially international companies or companies with foreign participation, you always need to get some permits from Interior, some permit from NCDMB, and justification why you have, you know, international people on your board or in your management and all that. Liquidated damages is also something that is very important in a contract. And I've categorized them as performance and delay. So if the contractor delays in delivery of a certain item, you could say, I would charge him $1 million for every day until the day he delivers. So if he doesn't deliver after 10 days, then you know he owes you 10 million. So it's liquidated because you don't need to argue. We've already stated it. This is how it's going to be calculated. And where there is a default, you just do your mathematics and you tell the contractor, pay me. The same thing applies to performance, depending on the performance requirements for maybe the plants and all. If it doesn't meet those requirements, depending on the losses, usually that you would incur as a result of the non-performance of that particular equipment, you would design, you know, what your damages would be, and it's just be a simple multiplication. For every time this plan does not meet XYZ performance, you will pay me this. So it's very important to have those things included in the contract, especially where time is of essence. You usually have delayed damages. Where performance, you know, the plan meeting certain expectations of essence, you usually have performance liquidated damages. Then of course, your regular warranties, representations, your payment terms, very important. Default, what amounts to a default? What are the consequences of default? What are the remediation opportunities for either the contractor or the company? Those are very important. And finally, the scope of work. I always say that no matter how well the lawyer does their job, if the work is not well scoped, the contractor will always, you know, the contractor will be very happy. He'll keep bringing variations, contract variations. So and that's the work of the technical team. They need to take their time to scope the work, provide, you know, very clear details, you know, for the scope of work. The way Dennis is looking at me, I think my time is up. But I'll just quickly talk about regulatory compliance and just pretty much issues, you know, nothing really serious. I think personally that the energy sector is overregulated. This results in high cost of compliance for operators. That's why they have people like me, and you keep employing lawyers upon lawyers upon lawyers, because you're dealing with so many regulatory issues. For example, you'll get a letter from like a River State Inland Revenue Service, and then they would just give you a list of maybe different bylaws. And under this law, you're meant to pay this, you're meant to pay this, you're meant to pay this. And then you have to take your time, look at those laws. You realize the law doesn't even say you're meant to pay this, or the law doesn't even apply to you, And whilst you're dealing with that, you get another letter from this Ministry of Environment, Local Government Council, Village council is not a regulator, but different issues. And I think for me, most recently would be this issue around the scope for the upstream regulator and the midstream and downstream regulator. The PIA wasn't very clear in terms of who takes responsibility, for example, over terminals. And so we had issues at a point where the upstream regulator would send you a letter saying, if you want to get your export permit, you must apply to me. Whilst you are dealing with the upstream regulator's permit, the midstream and downstream regulator will send you a letter saying, if you want your export permit, you need to apply, you need to apply to me. And it was really difficult. And then we then later had there was a presidential directive that was issued, and the presidential directive then transferred certain powers of the authority to the commission. Now, based on the law, what the president did was wrong, but now you have a presidential directive saying you should deal with the upstream regulator, if for your terminal, activity, anything up to the door of the terminal. But that's not what the law says. So this creates a lot of confusion for operators, confusion for people who want to get into that business. And I don't think it's good for business. I personally also don't think that it was really necessary for us to have a split between the upstream and the midstream and downstream regulators. I think we should just have a single, that's my own opinion, but that's not what the law says. But we have so many regulators, so many taxes as well that an oil and gas company needs to pay. The administration of that also is very expensive. It's time consuming, it's stressful, it's confusing for many operators. So I would also as well propose it would be better that we had, just a single tax, for example, and then every other person comes to pick their quota, so to speak, from that single body of tax that the oil company has to pay. So those are just few comments around regulatory compliance issues. But like he mentioned, if you don't comply, you are exposing yourself to serious penalties. For example, under the PIA, the operator is meant to devote 3% of its OPEX for the preceding year to the development of its host communities. You're meant to fund the host community trust fund with 3% of your OPEX. That's a lot of money. And that's money that most oil companies would not want to let go at once. But the law doesn't say you should pay it in bits and pieces. You're meant to pay, that particular 3%. And recently, the commission sent a notice that operators who don't pay and who don't fund the host community trust with 3% of their OPEX, they are going to lose their license. And so when you get letters like that, that wherever that money is, you have to look for that money. You have to pay it into the trust fund, because if you don't do that, you would be exposed to, you could lose your license, and that could create defaults on multiple grounds, right? And I think there's also the image, do you get, as a company working or operating at that level, you don't want your name dragged in the news, or in social media as being the irresponsible company that doesn't care about their host communities and things like that. So you want to be responsible just so that you can keep presenting that image of, a responsible company, because that image too is capital. That goodwill is capital for you when you're trying to raise funds. I think we've spoken about dispute resolution already. It's a question of law and contract, because some laws like the PIA would provide, or regulations will provide a mechanism for dispute resolution in that particular sector. We talked about popular dispute resolution options. I can't really go into this. This is another another, it's a lot, arbitration, mediation, negotiation, litigation. Just briefly on mediation, we had a dispute once with some foreign investors, and based on the agreement, we were meant to have this initial negotiation between parties, senior management of both parties, before we go to mediation and then arbitration. But we felt like our case was so strong, and the counsel we gave management was that there was no need to settle whatever it is. Let's go to arbitration, because we know that when we get to arbitration, whatever costs we've incurred, because arbitration is very expensive, especially international arbitration is ridiculous. You don't even want to know how expensive. It's too expensive, honestly. But we were so sure that we were going to recover our costs, and the other party didn't have a case. So when we went into mediation, we went to mediation thinking there's nothing this mediator can tell us. We are going to arbitration. My dear, by the time this mediator finished working on us, we found ourselves in a situation where we were actually saying, okay, so what can we give the other party? How can we settle? And it was, honestly, I would recommend that mediator to anybody. If you think you will not settle, by the time that mediator finished working on both parties, we ended up coming to a negotiated settlement. It cost us something, but it also wasn't all what the other party felt they deserved. Right. So dispute resolution is something, it's very interesting, when you get to see the things you have read, maybe in law school and stuff, you get to see them play out, real life. Litigation, is very interesting. In a country like Nigeria, litigation is very interesting. Yeah. So I think that's just a summary of everything I have to say. And I hope you've gotten one or two things, and I hope I didn't take too much time. I kind of feel like I did, but I'll stop here. Thank you so much. Yeah, bye.
Okay, thank you very much, Ms. Obo, for that wonderful presentation, taking us step by step through contracts resolution disputes as regards the oil and gas sector. Thank you so much, man. I'm sure our mentees learned a thing or two from there. All right, so we would like to have our next mentor, Mr. Alexander, also come up and give us his discourse into today's topic. Mr. Alexander, you're welcome, sir. Thank you for joining us, sir.
Okay. Hello, everyone. Good afternoon.
Good afternoon.
Yeah, good afternoon. So, my co-mentors have already spoken so much, and I just have the feeling that they are just talking to the lawyers. And Dennis, please confirm, are all the mentees lawyers? I just want to get a response.
No, I think we have maybe one or two that are not lawyers.
Are non-lawyers. Okay, so yeah, because I noticed that Ayobami and the second mentor mostly is as if they're just talking to lawyers, and I'm like, it's contracts and regulatory compliance only for lawyers. So I'm a non-lawyer, I'm not a lawyer. I studied economics, and but I was into that space. I was a regulatory manager at Ibadan School. So my focus will be more on the Nigerian power sector as against the oil and gas, where my mentors have spoken extensively about. Though, from what I know, there are areas of overlap, you understand, in terms of almost everything that they've said. So I just don't want to repeat what they've said. So talking about contracts, in the Nigerian power sector, we have different types of contracts. We have the vesting contract, which is an agreement between the DISCOs and NBT, Nigerian Bulk Electricity Trading PLC. Right. So in that contract, the contract just itemizes how power is going to be purchased. So if you know the electricity value chain, you know that most of the gencos in the country purchase or are gas fired, right? And between those gencos and the gas suppliers, they have agreements as well, gas supply agreements. gas purchase agreements and the like, right? Even there are transportation agreements as well. Then between the GENCOs and NBT, we have power purchase agreements. Between NBT and DISCOs, successor DISCOs, we have vesting contracts. So the power sector is a sector that has a lot of contracts. Without contracts, many things are not going to go well. So, talking about power purchase agreements, one thing I know is that if I'm a financier, I'm a JP Morgan or any kind of investor, and you do not have a contract, there is no way I'm going to want to invest funds into that kind of business. So it's just like saying, because of the challenges in Nigeria's power sector, you know that a lot of these GENCOs, they pump in a lot of energy into the grid, and the DISCOs cannot collect due to the very high ETC and C losses, and remit about 30% down to NBET. NBET remits just a little percentage down to GENCO. So to some extent, you need some kind of guarantee, right? You need some kind of contract. So that is one of the reasons why we have contracts, just so that even the investors can have some level of confidence and give you funding or finance for that business operation. On the DISCO side, it's just saying that, okay, you know what? I'm going to buy, like, just say 500 megawatts of energy from NBT on a monthly basis. And just as I like the presentation from my commenters, because they really gave us an overview of what the contract is all about. The contracted capacity, how much you're going to take, how much energy you're going to take. This is how bills will be settled. This is the period of time you must pay your bills. This is when the bills are going to come. This is when you must pay. Liquidated damages, just as has been explained, right? So there are a lot of things that are in this contract, and lawyers, you know what to look out for, but even the non-lawyers also. I mean, most of the best contract administrators I've seen in Nigerian power sector are not even lawyers. Some of them are even engineers. Back at NBET, when I was in NBET, my bosses, I mean, the head of contract management was even an engineer. You understand? So, I'm just saying that even non-lawyers too can actually administer or manage contracts, right? Then the second phase is let me see. The second phase, I think, is regulatory compliance. So we know the Nigerian power sector is regulated by NEC, and NEC, and NEC issues orders, NEC issues orders, regulations, and some kind of directives in the power sector, for the power sector. So all these orders and directives have to be complied with. Without compliance to them, you expose yourself to fines, sanctions, even your business can be shut down. And even regulatory compliance also transcends even the orders. It also applies to the Electricity Act 2023 as well. Before it was ESPRA, but now we have the Electricity Act. So we have to comply with the Bible of Nigerian power sector. So first of all, the Constitution. Second, we have the Electricity Act. Then thirdly, we have whatever is issued by NEC to the power sector. Then dispute resolution. Dispute resolution is embedded in contracts, because in most of these contracts, as I've mentioned, whatever it is, whether GSA, gas supply agreement, gas purchase agreement, power purchase agreement, whatever contract, there's a component where the methodology for settlement of disputes is embedded, right? So for most contracts, I know they push for arbitration, where parties will nominate an arbitrator, and even the location for where the arbitration is going to take place, and who also bears the cost for the arbitration process. But besides that, also in the Nigerian power sector as well, so most of the DISCOs always used to run to the courts. I mean, everything about the disco. You always want to go to court, to take neck to court, to take embed to court, take minister power to court. And these issues drag on for a very, very long time. Though sometimes, I mean, even when I was in the disco, I saw that going to court had its own benefits because most of the times you maintain status quo, especially when it favors you. You understand? So I'll just stop here. And yeah, thank you.
Thank you very much, Mr. Alexander. Thank you for that small discourse on contract resolutions, contracts, as especially from your own point of view as regards the power sector, and in most regards for also those that are not necessarily in the legal space. So thank you very much, sir. We appreciate you, sir. So we would like to have our last but not least on our mentor list, Mr. Okeogene. Thank you so much, sir, for joining in on the call, sir. We would like to give you the floor, sir, to also have your discuss on the topic of today. Thank you, sir, for joining.
Yeah, good afternoon, everyone. And thank you, Williams, again for having me.
Thank you very much.
Interesting topic. I think I've learned a lot from my fellow mentors as well, from the lawyers and the non-lawyers. I really don't want to go into saying so much because I believe they've touched on very important parts. I think the first two speakers, Abayomi and Ms. Obo, I think they've touched on very critical areas on contracting and dispute resolution. I think this is what some of the things that our mentees need to take very, very seriously. What are the implications of non-compliances on contract, scope of work development? They are very important that you capture all what is required. And like Ms. Obo said, the engineering team, that will be us, that's what we do. We develop most of the scope of work of what needs to be done in most oil and gas contracts. And I mean, they went ahead to say about a few things, but I believe they've touched on every area. And also, Alexander has also touched on the non-engineering part, which has to do with contracting generally and how contracts are developed from his own point of view. For me, sorry, let me not take your time again. I think this is a very, very important conversation. An area that I also want mentees to look into. Sorry, hear me, please.
Yes, sir, we can. For a
Okay,
brief.
Yeah, sorry, I have someone calling in, so it's inhibiting my call. But one area I really want to guide the mentees is to go to the new PIA Act, to have a read through, right? We have a lot of unclear areas and teething issues in terms of what the authority and what the commission, I think it was also touched on here. Myself and Abayomi, we've talked about it extensively, and I like the way Ms. Obo talked about it as well, where there's a lot of punching and, gray areas on authorities and what they ought to do. But the PIA from the other act we had in 1990 has gone 10 steps ahead again to provide clarity, although we will not say a lot of areas have been touched. There are still gray areas again that we have also identified and pushed back again to the review of the PIA. But I think for today's class, I believe that the mentees have a lot to go back and look at. And before you come into the energy industry, you want to have experience in the energy industry. I think most of the issues talked about, especially contact management and also resolution of issues on contracts, we need to look into. I'll just want to support when they get to the question and answer section. But I want to thank my mentees. I think they detailed enough, especially with the presentation that we had. I think she took step by step. I took a lot of notes on some of the things she talked about. And I'm quite impressed. And I hope the mentees will pick as much as they can for this. My background is engineering, as you know, so this is not my forte. Yeah. Thank you very much.
Thank you very much, sir. Thank you still for joining us, even though you are not a very, very law inclined. You are not law inclined, but all the same, sir, we still get to learn so much from you. So we thank you so for joining us, sir. Thank you for being here, and also thank you for sharing your knowledge with us. So we'll be having presentations now. We'll be having presentations now from our mentees. Group 1, I don't know if the backup presenter for Group 1 is available to present. The group presenter just told me he will not be able to present. So can we have the backup presenter help us present, or any other person from the group? Okay, if they will not be able to do that, let's go straight to Group 2. Then we'll go back to Group 1 while they try to sort out their presentation. So Group 2, please, you can come up and make your presentation. Thank you.
All right, thank you. Please give me a minute to sort things out here. Thank you.
All right.
Please, I am having an issue sharing my screen. Please, I will sort it. Just give me a minute. Thank you.
Okay, let me help you share the screen while you make the presentation. Is the presenter still with us? Hello, Tomilola. Are you still with us?
Yes, I'm still with you.
All right,
Can
let
you
me.
see my screen now?
Okay. Now your screen is.
I'm so sorry for the delay. All right, so we'll be talking on dispute resolution and what is going on? Okay. All right, so oh God, I'm so sorry for all this. Okay. Dispute resolution is the process of settling disagreements or conflicts between people or parties. And we'll be discussing the overview of dispute that arises in the energy industry and how this risk, that is disputes, can be effectively managed. Globally and locally, the energy industry is bound to be mired in different disputes due to the nature of the industry. For instance, the international petroleum business invests in large, complex, capital-intensive projects that have long lifespans. And the changes in circumstances, economy, government, and parties often lead to a dispute. So the process of settling this dispute and disagreement or conflicts is what is referred to as dispute resolution. And there are several methods of dispute resolution that we have. Here we have litigation, alternative dispute resolution, and I think expert determination. Yeah. So first, we'll be looking at litigation. Litigation is a formal method, process, or act of settling conflict or disagreements in court. Where parties have failed to reach an agreement, they would approach the court to settle their dispute. It is one of the most familiar resolution tools to legal practitioners and like mostly lawyers, all right? So we have three pros of litigation here. The first one is that it ensures clear resolution between parties as the decision of the court is binding on all parties. Parties are guided on the outcome of their litigation through existing judicial precedents. We have clear application of evidential rules and procedures which ensure fairness because parties present or defend their case in similar manners, which is a clear application of the rule of common law, which states that both sides of every case must be heard, audi authorem partem. Yeah, and we also have the cons. Our mentor mentioned that litigation, like through litigation, you might lose substantial relationship. And yeah, we also have it that litigation is expensive and time consuming. She also mentioned that it takes a lot of time and you spend a lot. And like from what I have seen and learned, cases might go on for 5-10 years and might not still like have a way to resolve it. Then we have notwithstanding existing judicial precedents, the outcome of the proceeding is uncertain. Yeah, that is very true because like regardless of what you think you have, like she said, they thought they had a case until they met their mediator, and you don't even know what the outcome will be. It is very, very uncertain. Then due to formality of its process, evidence are available to the public, and this could be inconvenient to the party. Yeah, your image, she also mentioned that when she was speaking, your image is at risk, like what people see you as when the whole formality is out to the public, it might be very, very inconvenient to the parties of the litigation. Then litigations could bring about damaged relationship. I already mentioned that. Then we have ADR, alternative dispute resolution. It's simply an out of court settlement. Yes, it is a direct opposite of litigation. It is an out of court form of resolution. Through ADR method, though the ADR method is an out of court settlement, it is governed by certain rules and procedures, which may not be strict. All right. Yeah, we have that there are 4 types of ADR method, and they include conciliation, negotiation, mediation, and arbitration. All right, so negotiation is a provision for negotiation may or may not be drafted into an agreement. It is an ADR method which allows parties to a dispute or disagreement to meet, discuss, and settle their variances amicably without the presence of a third party. This is less common than other ADR methods, and it can be formalized as part of a multi-step dispute resolution process. Like the agreement needs to set a clear time frame for each step upon completion. Otherwise, failure to complete one step at a time could lead to an obstacle that might avoid the parties getting a binding resolution. Yeah, it is the least expensive of any dispute resolution and potentially the most commercially viable solution. However, it needs full cooperation of the parties to avoid negative emotions and view that may get in the way of settlement. Yeah, we also have conciliation. This is a similar method to mediation because parties resolve their. It is similar to mediation because parties resolve their dispute in the presence of a third party known as the conciliator. A conciliator can only make suggestions to the party, but these suggestions or opinion are not binding on the parties, as they elect to adopt the opinion of a conciliator or not. Then we have mediation. Okay. So mediation requires the parties to be, I'll say, well prepared and committed to the process. Their decision makers must be at the table, and a skilled mediator must be at the table to work for the mediation to work properly. And when all these people are present, mediation can be a very effective and successful dispute resolution tool. Yeah. It is an alternative from litigation and arbitration. And one thing that is very important to know is that mediation is not a legally binding process. The results of a mediation only become binding when a signed settlement agreement is, and when an agreement is signed, all right? It should therefore be, it should not be seen as a binding process, not a replacement of a binding process, all right? It is an adjunct. Yes, that is it. It is an adjunct. Then we have arbitration. Oh, okay. Yeah. Arbitration can be seen as a quasi court or mini court, because some rules or procedures guiding litigation apply immediately. It is the most widely accepted and used dispute resolution method in the international energy sector. And the resolution from arbitration is called an award. However, an award is final and not subject to appeal. Yeah. Arbitration is manned by an arbitral panel who are referred to as arbitrators. On agreement by both parties, they present their case, tender evidence, and argue their cases before the arbitral panel, who gives a decision based on their arguments. The decision of an arbitral panel is binding on both parties, and it is called an arbitral award. Yeah, I mentioned that. And an arbitral panel sits for a few hours in a day. It is worthy of note that parties must be in agreement before adopting an ADR approach. All right. So an award is not subject to appeal, like I mentioned. However, it can be appealed on circumstances that are under section 29 and section 30 of the Arbitration and Conciliation Act of 1988. Yeah, I'm not so sure about that though. I think section 29 and 30. All right. So an award can be set aside if there is a misconduct of any form on the part of the arbitrators, or maybe in the award, the arbitrators exceeded their jurisdiction, all right? Or if there's any error of law in the process of the arbitration or in the face of the award. Okay, so we have expert determination. Expert determination is like you are bringing in someone who knows so much about this particular course of study to help you settle a dispute you have in that particular course of study. Yeah, it is. Although it is not widely used in dispute resolution, and when it is used, it is mostly used on narrow technical grounds. Yeah, most times expert determination faces difficulty when the matter is of facts and of law, which is mostly the case. And it is only effective in highly technical matters. All right, so yes, we have pros of alternative dispute resolution. Number one, it is cost efficient, unlike litigation, and it does not consume time, unlike litigation. And the methods are satisfactory to parties concerned. Yeah, because most of the time, I think one of our mentors also mentioned is that the parties, you are able to pick what you want, especially in arbitration, in the international arbitration. Although it is very expensive, you're able to pick the venue, what you want, how you want it to be settled, and you're able to like present your case as you want, as the satisfactory to the parties concerned. Yeah. So it gives parties greater control over the resolution of their disputes. Yeah, the method of resolving this dispute is mostly left in the hands of the parties involved, and it enhances amicable settlement of disputes, as parties could relate with each other after settlement of their disputes. Yes, your image is not as risky because it's like it is an in-house something. It is not open to the public that much. All right. Then the cons. In some cases, ADR methods do not yield a positive result or settlement. Yeah. The decisions of ADRs are final in some cases. It's just like we mentioned in arbitration, especially. So then ADR are not applicable in all cases, such as in criminal matters, which is against the state. Because if you want to, maybe you bring everybody in the state or the government parastatals, you bring them together, and that is almost impossible. Then we have parties may fail to disclose fully certain facts, which would aid the settlement of their disputes, and also witnesses cannot be compared to give evidence as investigations. Yeah, you are the parties to this dispute. They might want to withhold any form of information, and the witnesses around are not really compelled to give evidences. All right. Then the decisions of an ADR method may be biased and tainted with fraud. All right. And let's go to disputes in the energy sector. As said, the energy sector, due to its economic importance and geopolitical factors, has often been mired in many disputes globally. Disputes are inevitable in the energy industry because of the frequent use of joint venture structures, the reliance on contractors, and the long list of engineering and geologic complexities. Like, because when the mentor was talking, I was just like, what is all this again? Like, it is so complicated. So there's no way disputes can be avoided. It will surely happen. So it's just best to just have means of solving them. Then we have the international disputes. International disputes. Following is the list of some prominent and recent international disputes in the energy sector. The first one here is the Argentina and United States JIIPCCMIP.
Sorry, Tomilola, please, can you begin to round up so that we can have the other groups, we can have our mentors' comments, then the other groups' presentation. Thank you.
So the Argentina United States BIT, I think that is the bilateral investment treaty. Yes. Yeah, and it was signed during an economic crisis in 2002. Argentina annulled gas contract, leading to US companies to commence international arbitrations. And then we have the Russia-Ukraine gas dispute. This disagreement over gas prices and transit fees has begun since the early 2000s, and it started from Russia cutting off Ukraine from their gas supplies, and it also affected European countries. However, it was eventually settled by the European Union. Yes. So the war is still continuing. Like all this, like through everything, the war that we have now, the current war of Russia and the recent one of Russia and Ukraine, it's all dates back to the cutting off of Russia from Ukraine from Russia's power supply. Then this is the South China Sea territorial claims. Then we have the African regional disputes. Some major energy disputes in Africa are listed below. We have the Cameroon-Nigeria-Bakassi conflict. It ensued due to a territorial dispute over the Bakassi Peninsula, and it also affected the oil supply. And we also have the Somalia-Kenya maritime dispute. This dispute between the East African countries is mostly on about the maritime boundary on a potential resourceful offshore. Then we also have Nigerian disputes. We have the Ogoni environmental crisis of 1990 to 1995. And also recently, I think the host communities, I think on 4th of May of this year, they complained about losing people and the environmental degradation that has been happening in their community due to oil exploration and oil spills and everything. So they said they wanted to sue oil companies and the Nigerian government for, I think, $1 trillion. Yeah, $1 trillion very recently. So we still have it ongoing. Then the Niger Delta host community issues. Yeah, that's what I just talked about. All right, so the dispute resolution must balance energy, economic, and sovereignty interests. Environment that are supportive of investment, yet sensitive to social licenses to operate, are critical to promotion of sustainable development in the energy sector. So we also have points of consideration for players in the energy sector. We have the project feasibility and due diligence, regulatory compliance, risk assessments, financing and funding, offtake agreements. We also have the technology and equipment, environmental and social impact, land and infrastructure, government support. Our mentor mentioned some of these, and the key clauses in the investment agreements. We have the amendment clause, termination clause, like our mentor already mentioned that. Once you are entering into a contract, look for the exit door, know where it is, so that when you want to leave, you are able to leave ASAP. Then we have the stabilization clauses, the liability clauses, financing clauses. Yeah, these recommendation clauses are not exhaustive and can vary depending on the specific nature of the energy project, its location, and the parties involved. All right, thank you very much.
Thank you to Tomilola for that presentation. Thank you for stepping in and representing your group. Group members, you can comment. You can show your appreciation to Tomilola. You can send your emojis telling her job well done on the presentation. But before, we will just be going straight to having our mentors. Sorry, we will just be going straight to having our mentors comments on the presentation that was made. So we'll be having, I think Miss Ogbo is still on call. She said she will be leaving soon, so we'll be having her first. Miss Ogbo, please, you can come and give your comments on the presentation that was made by Group 2. Okay, it seems it's not with us anymore. Please, can we have Mr. Ayobami? Mr. Ayobami, sir, can you give your comments on the presentation made by Group 2?
Yes, I mean, good work. This resolution is a very, very critical part of any transaction or any commercial transaction around the world, basically. And there are some things I noticed and some clarifications I think I should make. You mentioned the judicial precedent, and yes, the legality of judgments in the country is always based on judicial precedent. I mean, once a higher court has, like for example, Supreme Court is the highest court on the land, and once they declare something, then other courts, down the ladder, the Court of Appeal, the High Courts, and they have to obey the precedents set by the Supreme Court, And but yes, there's a way of that's called distinguishing cases, where a lawyer comes and that lawyer says, yes, the people that said this is what should happen. And that lawyer will now come and tell you that, yes, Supreme Court said that, but he will try to distinguish the facts of this particular case from the facts in which the Supreme Court declared. You say, oh, when Supreme Court declared that issue, it was based on the bungalow building. Now it's based on the duplex building, So he will not try to distinguish it so as to go off the judicial precedent. So it's called distinguishing cases, just for your knowledge. Yes, you spoke about the Arbitration Act in 1988. I would tell you that there's a new arbitration that was used to be arbitration and conciliation under the LFN 1990. But now it's now Arbitration and Mediation Act 2023. Yes, so there's a new one this year, and you might want to get some abreast of the new law. So mediation, yes. So you also mentioned something about mediation, and that when mediation leads to settlement, then becomes binding. So what happens is that during the mediation session, when the mediator has been able to reach both parties and they both come to an agreement, it's always a settlement agreement. That settlement agreement is now being put before a judge, like a consent judgment. So it's not passed like a judge that, both parties and their lawyers will go to court and like, my lord, we are both agreed to this. Okay, this is agreement. So that agreement now becomes a legal pronouncement by the judge. So it becomes, this is what both parties have agreed. So this is what it is. So that gives credence to the agreement. So a settlement agreement has to be brought before a judge, you know, who will pass it like a judgment on that particular issue. So that's what happens after mediation. Then, yes, I think you mentioned something about that. Arbitration is final, but it can actually be appealed in court. Yes. So when there's a manifest error, or maybe the rules of the arbitration was not followed, or when there's illegality can be proven. So usually it's not always about the facts. It's usually about the manner in which the award was given, basically. You know, so yes, so it can be challenged on both. And a recent case is what I expected you to quote was the P&ID case that the Court of England, High Court of England pronounced at the previous arbitration that gave the Irish company $11 billion against Nigeria, that it was basically illegal. You know, so that's a recent matter I was expecting you to. Kudos on the Bakassi, Nigeria and Cameroon arbitration here, but this is more recent. I mean, it's as recent as a week ago, you know, and it was in all the dailies and newspapers. So that would be the perfect example of that. Yes, I was expecting to talk more on the regulation. Okay, yes, actually about the Arbitration and Mediation Act 2023. I was expecting to talk more about it. I was also expecting to talk more on the arbitration bodies and rules. We have the Lagos Multi-Door Courthouse where you can do arbitration, mediation, you know. We have the Lagos Court of Arbitration, you know, and so, or Lagos. So I was expecting to talk more on the bodies and their rules also, that, oh, this is an arbitration center we have around in Nigeria, you know, that anybody can walk into, you know, and both parties can have that codified in the agreement. So I was expecting to see more on that, which was missing. Then talking about the P&ID legal issue. So basically that's it. Kudos. I saw your references at the end. I mean, this is the first time it's ever happened. I've been shouting about this for all year round. So it's good that finally something has happened. And yes, I keep saying this thing. References was at the back, but also I preferred it like a footnote. So I mean, after each line, you put there'll be a footnote saying this line was referenced from this. But hey, it's a good start, you know, and this might be the last class section, but going on in future, where you're writing legal briefs and everything, they'll tell you that you need to reference as much as possible. Yeah. So good work, all in all. Interesting topic we have today, and I think it's something that the lawyers and, like Alexandra said, the non-lawyers also want to, you know, have a look, and it's always going to help you in your career. Yes. Thank you.
Thank you so much, Mr. Ami. Thank you for that wonderful contribution. I'm sure our parties are taking note of everything that you said, and well done, Group 2, for that presentation. Okay, we'll also be having, I think Miss Obo is here with us. I don't know if we can have her comments and observation on the presentation. Miss Obo, please, can you help us with your comments and observation on the presentation made by Group 2? Okay, I think she's still not with us. So we would like to have Mr. Alexander. Mr. Alexander, sir, can we have your comments and observations, sir? Mr. Alexander? Okay, since Mr. Alexander cannot hear us, Mr. Okeogene. Can anyone hear me?
Yes, William, I can hear you.
Oh, all right, sir. Please, I would like to have your comments and observation on the presentation that was made by the mentees.
Okay, thank you. Great presentation, I must say. I like the fact that Group 2 has come along and taken the podium first, and a good presentation, not bad at all, by the lady that took the presentation. I didn't see her name now. I like the fact, I think she has a legal background. She was able to run through the entire process, cited a few cases again. I don't have a legal background, but again, I'm very familiar with most of the cases already. My mentor also mentioned, I've been following the P&ID case, and I really expected that they were going to mention that because it's an epic case already that's been gone. And that case, why it's even very interesting is that it has a Nigerian connotation. One, two, arbitration court had given it already to the other company, and then again it was overturned in Nigerian favor again a few days that the ruling came up again. So I like those cases that are taking multiple facets again. Quite interesting. I know one of the comments that were made again is that the legal implication of contracting gives an interesting look to the oil and gas industry, and that's something I enjoy. Most times I jump into a room when the lawyers are trying to interpret some of the comments in contracts, and I find it very interesting. And that's the same thing I also find from the conversation we had today. But again, going straight to the presentation that was made, I think I like what has been done. Good job to the entire team. What I would have wanted them to be more specific was about talking about oil and gas specific contracts as regards turnkey projects. I think one thing I was also mentioned was arbitration as one of the options that can be used. But I think my fellow mentor that spoke before me had captured specifically some of the issues that were missing. But generally, I would say it was an okay presentation. I look forward to the next presentation as we go ahead, so we can give our final comments. Thank you.
All right, thank you. Mr. Alexander, are you with us, sir? Mr. Alexander, are you with us? Okay, Miss Obo, are you back with us, ma?
Yeah, hi. Sorry, I already had something I was meant to do by 1. Sorry, so I had sent a message to you that I was going to be unavailable, so I was already moving. Sorry, your question is comments on the presentation.
Yes, ma.
Yeah. I think we've had just one presentation so
Yes.
far, right? Because and the presentation had a lot to do with dispute resolution mechanisms. I saw there was some detail around conciliation, the law, negotiation, and all. For me, I felt it was a lot of work. I felt like they had put in a lot of work to actually provide like a lot of details and backgrounds to the issues they were highlighting. So I would say well done to the team. I think also that generally, same thing I mentioned earlier, when it comes to dispute resolution, I think a lot of it has to do with I think just the general philosophy of the parties to dispute resolution. I like the fact that the speaker, I think it was okay, that mentioned the P&ID case. I think one thing about arbitration, when you and they mentioned it as well, when you're talking about arbitration, a lot of people talk about like the finality of an arbitral award. So one of the issues that the P&ID case brought up was the fact, concerns around whether we can trust the arbitral process. So it was almost as though it wasn't just the Nigerian government and the huge, penalties that we were meant to pay under that award, but it was also the arbitral process on trial in that UK court. And at the end of the day, the courts, I think there might have been some political elements to that decision, but generally speaking, the law was also sound to the fact that where there are questions around fraud, and illegality, those are issues that can undermine the arbitration process and affect the enforceability of the arbitral award. So as much as arbitration is meant to be final, because when you've expended so much resources going through arbitration, you should just go ahead and enforce the judgment, right? The award in court. But where there are issues around fraud, illegality, corruption, there are so many issues that the UK courts flagged. Those are issues that are capable of voiding or making that arbitral award unenforceable. So I particularly enjoyed that discussion and that aspect of the presentation. But generally, I would say well done, very well done to the team.
Thank you so much, Ma, for that comment and observation on the presentation made by Group 2. Okay, Mr. Alexander, are you back with us, sir? Okay, since Mr. Alexander is not with us, so we'll just be having Group 1. Group 1, please, can you come and make your presentation? Please, we would like you to stick with time. 10 minutes, we're running on time. So please, can we have Group 1 present?
Please, can you confirm that you can see my screen?
Yes, your screen is visible.
Okay, thank you. So our topic is as regards energy contracts and regulatory compliance. But what we have done is that we have tried to, as opposed to looking at them as two different concepts, I've tried to look at energy contracts and how we can observe compliance as it relates to energy contracts. And this is particularly because we have, in previous topics, we have attempted to look at the regulatory framework of the energy industry. So what we have done here now is to basically combine the two of them. So an energy contract is simply a legally binding agreement between an energy consumer and an energy supplier. So that could be an energy consumer here could be a business or a homeowner, and the supplier could be maybe an electricity or natural gas provider. The contract usually outlines the terms and conditions of the energy supply, including the pricing, the duration, and other relevant terms, which basically involves adhering to laws, prescribed laws, regulations, and industry standards as set out by the various government authorities or regulatory bodies. So in particular reference to the energy industry, we'll be looking at the laws, the regulations and energy industry. So we have, okay, so for the background of energy contracts, what you have is that we had the period where we had the early energy transactions, which typically involved verbal contracts, involved a number of verbal contracts between individuals on how energy was to be maybe supplied and things like that. So this period was largely unregulated, as it was usually just conversations between individuals on how exactly they were supposed to supply energy and also take purchase or receive energy. Then from there, we moved on to the emergence of regulations, which stem from the growth of the energy in order to guide and govern the energy industry. Then you have energy deregulation for a number of countries. For a number of countries, you have countries deregulating the energy sector in a bid to promote competition and to also allow for choice for consumers. Then you have energy contracts, which basically represents a period where we now had formal contracts that were provided to basically govern how energy is supplied, how it is sold and purchased from between the energy consumer and the energy supplier. Then you have regulatory compliance. So in the wake of energy contracts, there's also the need to ensure that the energy contracts in many ways are able to comply with certain regulatory standards so that they can basically fulfill the purpose of the energy industry and the objectives of the energy industry. Then you have technological advancements, all of which is basically to ensure that the way we operate our contracts and the way the energy industry as a whole operates is optimal. And have finally renewable energy and sustainability, which basically revolves around moving from the use of fossil fuels as a source of energy to a more sustainable and renewable form of energy, which is around solar, wind, gas, and biomass, and things like that. That's the significance of energy contracts. We've looked at the significance of energy contracts as well as the significance of regulatory compliance. Can you still hear me?
Yes, we can.
Okay, thank you. So one of the significance of energy contracts is in price stability. So for price stability, what you have here is that there are certain contracts basically prescribe a fixed price for the supply of energy. So energy contracts are able to guarantee that you can have price stability as it relates to the supply and the purchase of energy, whether be it electricity, gas supply, and things like that. Then you also have the choice. You also have choice and flexibility. So customers are now able to basically pick and choose, or the consumers are able to pick and choose based off of the provisions of the contract. Then you have so they're able to decide whether they want to go into long-term commitments or they want short-term flexibility, whether you want it to be related to renewable energy or various things like that. Then it also provides for risk management. So in many ways, one of the major reasons why you have contracts is to basically optimize your risk, find ways to mitigate that risk and still go ahead with procuring energy as you would want. Then energy contracts also provide basically a framework for investment in energy infrastructure, to have contracts to regulate that investment in order to like I said, mitigate your risks and also create a framework for you to invest and also get a return on your investment. Then energy contracts also provide a legal protection. So what you are tied together. So that legal protection would also be utilized by the energy consumers, be utilized by people that are interested in infrastructure. So the legal protection will also serve as a means to mitigate your risk as well. So in many ways, you can see that these things are all interconnected. Then the significance of regulatory compliance, one of which is market integrity. So you have market integrity. Regulatory compliance basically ensures that the energy market operates fairly and transparently. So it helps to prevent market manipulation and anti-competitive practices. So what you realize from a reading of the Electricity Act of 2023 is that a number of the provisions try to, the idea is basically to move us from the transitional stage. Hello? Can I go on?
Yes, you can.
Okay. So I'm saying that one of the objectives of the Electricity Act is basically to move us from the first stage into the middle term stage and the long term stage. And the idea of the long term stage is that we want to have a fully competitive market where we do not have a monopoly and you have various parties competing in that market. So the idea of having market integrity here is that it helps with so regulatory compliance helps with preventing market manipulation and anti-competitive practices. You also have safety and reliability. considering how the energy industry is run, there is a very important need to basically comply with safety and reliability standards as it relates to energy infrastructure and operations. Then you also have environmental protection. It's difficult to speak about, to have conversations around the energy industry without making reference to things like climate change and how it affects the environment. So regulatory compliance is also important in ensuring that people are able to comply in ways that would ensure that the environment is protected. Then lastly is for the consumers. Regulatory compliance also ensures that the consumers on the final end of the spectrum or the value chain is able to be protected basically. So we've looked at the regulatory framework as a whole. So it's important to consider that the regulatory framework, or rather when we speak about the energy industry, we are basically speaking about we're basically speaking about two aspects of that. So we're looking at the value chain across the oil and gas industry. We're also looking at the value chain across the power sector, use of renewables and things like that. So when we look at the regulatory bodies, it's important to know that we're also looking at the regulatory bodies across all of that. So in terms of the regulatory bodies, we look at the NERC, which primarily governs how the power sector is operated. We look at the Federal Ministry of Power, which is in place to make policies and basically interface with the government as it relates to the power industry. We look at the Energy Commission of Nigeria, which is in place to basically provide strategic planning and coordination of national policies in the field of energy. We look at the Upstream Regulatory Commission and the Nigerian Midstream and Downstream Petroleum Regulatory Authority, both of which are basically to create policies and guide the way basically the entire value chain of the petroleum industry. Then we have the Ministry of Petroleum. We also have NNPC. So moving on, we have well, across the oil and gas industry and the power sector, we basically have the PIA and the Electricity Act. On the side of the PIA, we have so the PIA basically aims to overhaul the regulatory framework for the sector, that's for the petroleum sector, and it aims to promote transparency and accountability and also attract investment. Then, so the PIA seeks to provide a framework for the development of the Nigerian gas sector, as well as the Nigerian oil and gas sector, which, as we can all agree, has significant potential for growth and investment. Then you have the Electricity Act, which aims to consolidate the various laws and regulations relating to the power industry or the Nigerian electricity sector. And so it basically aims to consolidate it, promote the integration of renewable energy, promote investments in the power sector, and basically help us to transition from the transitional stage all the way down to the long-term stage. So we have compliance requirements as it relates to energy contracts. And like our mentor has said, we have a lot of templates as it relates to energy contracts. So individuals are generally free to enter individual contracts for the sale of I'll not say, let me say licensed individuals basically are entitled to, they are free to enter into various forms of contracts as it relates to the sale or purchase of power, oil, and natural gas. So you have a number of contracts, you have best agreements, the sale and purchase of power, sale and purchase of oil and gas. Now, sorry. Is that the general rules of contract or contract law generally govern and apply to all actions. So you see that the terms of the contracts are to be interpreted to the will of the parties that are subject to the provisions of the law. However, what you realize is that in relation to energy contracts, you see that energy contracts can basically be referred to as statutory contracts, in that a lot of the provisions in the contracts have to be tied to the laws. So they have to be tied to a number of the laws. So you have the market rules that basically provides that contracts that relate to the power industry must be in compliance or must contain provisions as relates to what is provided in in the market rules. So the idea here is that in terms of compliance as it relates to energy contracts, a lot of it must be tied to what is provided across the various regulations, as we have highlighted, some of which include the PIA and Electricity Act. So in terms of compliance requirements for energy contracts, while parties are free to enter into the contracts, its provision must be in line with the relevant rules governing the area of the energy industry in which it applies. So the impact of non-compliance on stakeholders. So you have financial consequences in the form of fines, penalties, pecuniary penalties, and things like that. You have operational disruption in the form of losing your licenses and how it affects how you are able to also have reputational damage. As an entity, you have a reputation as an entity, even as an entity and also as an individual. So failure to comply can affect how you operate, basically, can cause a disruption to how you operate. Then you also have, and to your reputation as well, then it also has legal ramifications in the form of dispute resolution, as we have had conversations around in the previous session. Then you also have environmental and safety risks. So like I highlighted previously, some of the provisions in the contract, safety and environmental standards are put in place to ensure that we're able to do away with this environmental and safety risks. So now we have case studies for some of the successful compliance that we've seen. So you have, so I'll just highlight a few of them, but we've also provided references to guide our reading. So we have the Microsoft's renewable energy commitment. So around 2020, Microsoft made a groundbreaking commitment to become carbon negative by 2030 and to remove all historical carbon emission by 2050. So in view of that commitment, they basically entered into numerous power purchase agreements to secure a substantial share of their electricity from renewable sources such as wind and solar. So what you have now is that the outcome is that by adhering to that contract, like we have said, by basically complying with that contract, they have been a Microsoft has been able to achieve a significant reduction in its carbon footprint and also benefiting from stable energy prices over the long term. So you have Google as well, which made commitments to 100% renewable energy. So they set a bold objective to match their entire annual electricity consumption with renewable energy purchases. So in view of that, they also entered into power purchase agreements and invested in renewable energy products on a global scale, ensuring a consistent and substantial supply of renewable energy. So in view of that, of the compliance with the relevant contracts that they entered into, Google was able to achieve its goal of operating on 100% renewable energy in 2017 and has since continued to maintain its momentum. So I will just look at the other side of it. So on the flip side, where we now have compliance failure between 2000 to 2001. So the California energy crisis was characterized by rolling blackouts, exorbitant electricity prices, and severe power shortages. So energy companies like Enron were accused of manipulating energy markets and failing to deliver on power purchase agreements, contributing to the California energy crisis. So the outcome of this non-compliance actual financial burden on the states. Sorry?
Please, I want to request that please you should start rounding up so that we can have our mentors' comments, then we can go to questions. Thank you. Please just start. Thank you.
Okay. So I was just going to say that the impact of this non-compliance was that we had financial burdens on both the state and the consumers, and they now prompted regulatory reforms and increased oversight to prevent future compliance failure. So key contractual clauses related to compliance. So in order to ensure compliance in this contract, you have things related to promoting environmental standards, things tied to regulatory compliance. We have safety and operational standard clauses. We have things for monitoring and reporting clauses. We have dispute resolution, which is also always very important. We also have force majeure clauses. So best practices would include a comprehensive contract review to identify risk, optimizing the process to save money, implementing technology that is using e-signatures, boosting communication and collaboration across stakeholders to prevent misunderstandings and to create alignment. Also, educating and empowering teams to maximize efficiency, mitigating risks strategically in order to safeguard interest, and also embracing contract management software to automate repetitive tasks. Then you have future trends in energy regulatory compliance. So we have the Electricity Act that has come in to basically create new provisions as relates to energy, as relates to power rather, and as relates to compliance. We also have the PIA. We have the introduction of energy smart contracts. So this type of contracts will be powered by blockchain technology. And so in the future, there will be revolutionary solutions to enable secure, automated, and decentralized energy trading. So this is basically looking at the future and what it holds in terms of how we look at contracts and compliance. So in conclusion, energy contract regulatory compliance is the cornerstone of a well-functioning and sustainable energy industry. Energy contracts can serve as a bedrock for efficient and predictable energy supply, providing consumers with choices, price stability, as well as legal protection, which is paramount. Compliance regulations, on the other hand, ensures that the energy market operates fairly, transparently, and responsibly. Energy contracts empower consumers and suppliers alike to offer flexibility, risk management, and opportunities for renewable energy investments. Regulatory compliance, in turn, upholds market integrity, safety, environmental protection, and consumer rights, all while fostering investor confidence and supporting the global transition to cleaner and more sustainable energy sources. So together, energy contracts and regulatory compliance play a very pivotal role in shaping the future of the energy industry, of the energy sector, while driving innovation and paving a way for a more reliable, environmental responsible, and consumer-friendly energy landscape. So this is our presentation for.
Thank you so much, Mr. Ayobami Elias, for that presentation. Well done. Thank you for stepping up for your group to make that presentation. I want to see comments from the mentees saying, well done. You send your comments into the chat box. Tell Mr. Ayobami Elias, well done. He did well. He was not supposed to present today. He's not the presenter, he's not the backup presenter, but he was able to deliver that wonderful presentation. So well done on that. So we'll be having comments again from our mentors on Group 1's presentation. We'll have, okay, Mr. Alexander said he had to go. So we'll be having Mr. Okeogene first, and then we'll have Mr. Ayobami, then Ms. Obo. So can we have Mr. Okeogene, sir?
All right, thank you very much. Ayobami, I think you did a very good job. It's very fluent in your presentation. And I don't know why you were not the primary presenter in the first place, because I think you did a very good job. I liked the way that you presented a bit differently from what we had the first time. Energy contracting, you looked at it from a very energy-related perspective, not really oil and gas. I think I like that flair. I'm an operations person, so to speak, so I like the fact that you brought issues on environmental concerns, safety into your conversations as critical factors in the energy contract, because whilst it's customer based or a two-party kind of contract, there's also room to respect the environment of the contract or jurisdiction, so to speak. And I see that you guys took your time to talk on that and make all those considerations. I think that was very, very worthy of commendation. Also, I think your presentation style was quite good. You were very clear in your delivery, what you did. So I think you did a very good job. Tops on. I want to give you so much kudos, because again, not being the major presenter, you were able to deliver to this point. Generally, in the energy industry or in energy contracts, there's room for both parties to respect the contract, having signed it. There has to be major issues for somebody to violate it, and I think you captured that also in your discussions. I think those are the comments on top of my head I can't remember at the moment, but I'll say kudos to the group.
All right, thank you. Thank you for that. Mr. Ayo. Mr. Ayo, sir.
Okay, yes. Some background noise there. That's a bit confusing here. So yeah, I mean, now this also goes for the first team that spoke on this resolution. I still feel both teams were lacking originality. They told us things that is happening, things that we know, but I was still looking for a solution, for them to provide solutions on where do we go from here. You know, I mean, to talk about the past, present, and it's a future solution that we're looking for, and that's the aim of every research work. You know, you can criticize, you can applaud, but hey, you should add a bit of more thing to the research world. You know, that's basically that. Good work, Ayobami. I think I don't know how topics are being given, but this was a too large a topic. You know, combining contract and compliance, and it did well. I preferred it to be handled by two different groups. You know, but did as well as you could, and that's I mean, but yeah, you had a difficult topic, yeah, and that's I give kudos to you for that, yeah. So, on the regulatory bodies part slide, I just wanted you wrote NNPC, preferred you write NNPC Limited, separating the old NNPC from the new NNPC. Now, if you have been listening to me in the past few weeks, I will always tell you that there's no difference to me, because I still feel the NNPC is being run like the old. But based on the PIA, which introduced the upstream commission and downstream and midstream authority, there's a difference in it. The new NNPC is supposed to be run like a limited liability company for profit, you know, and not get involved in policy making and declaring the price of fuel and all those things. No, that's not supposed to be their aim. They're supposed to be like a Chevron or a Mobil or thereabout, you know, a private limited liability company. Yeah. So then on the regulatory bodies too, I think since you delved into a lot of renewables and climate, I think you should have also included the National Council of on climate change. Yes, there's a council that regulates and the act they regulate is the Climate Act 2021, which is also included in the regulation, you know, and also in regulation you didn't include Nigerian Energy Transmission Plan 2022. It's a policy framework that says Nigeria would hit the net zero climate obligation by 2060. You know, so that's quite an important policy document that have been as part of the frameworks and all the regulation. So yes, I was expecting to see more on the you talking more on the climate compliance issues. Yes, and what Ms. Obos said earlier, lawyers and non-lawyers involved in compliance have always complained about it's quite stressful because, you know, the government agency, for example, some of them still good news that the old DPL, now NUPLC, went fully automated. But other government agencies like in the MASA, that may try to go to your automated level, where you still have to put in a written application. And you put in a written application to the body, then you go there, pick up your bill, go to the bank, use remitter, pay, take your receipts back to the company, and wait for your certification. Yeah, it's true. Imagine now a vessel having like 20 documents, so that alone is you need a whole compliance team to do that. So it's stressful, and guess what? You see, for example, when it comes to offshore, that has to do with rigs, FPSO, marine vessels, you will see NEPLC, ODPR, and the NIMASA issuing similar documentations, something they call conditional survey. You do it for a vessel. NPC and the master will say you should do it. DPL now in PLC, you say you should do it. And you can't use the master's own for any PLC. So there are a lot of clash between government agencies, and it's been turned into let's make money. When the NEPLC started the license to operate on it was meant for rigs, but extended to marine vessels. And marine vessels is supposed to be under the purview of NIMASA, that's Nigerian Administration Safety Agency. And the first year, the license cost was 120,000 naira. And the next year, it's skyrocketed to $15,000. And I'll be like, what is this? And they'll tell you that they need conditional survey documents, which you would get for the vessel when you're doing for NIMASA, but they'll tell you that NIMASA is different. So compliance is still, it shows that, agencies are out to make money, and they do it in a stressful way. Like one of the mentors said, I wouldn't mind you tell me that, all your certifications will give you one document, everything is so amount, but you have a lot of documentations. At one time, like I said earlier, I was handling over 100 documents for just like 3 or 4 vessels. And you'll be wondering why that much. And multiple, the ones for NIWA you do. One time NIWA and the master had a clash on the maritime part. So one time the master had a clash with LASEP, and LASEP, I think that's the Lagos State Waterways Agency. There's one time it's an argument on what the law says basically. Some part of the time there was the argument on is an FPSO a vessel, is a badge that can be moved on its own. Is a vessel. So the argument was that if you can't move something on the waterway, it's not supposed to be a marine vessel. Others are saying no, as long as it's in the waterways, it's floating or anything. So we still have those teething problems in our laws, declaring our laws, what they say, and no interpretation, because I know you find out that multiple agencies are still getting compliance certificates from the same compliance certificate from 2 multiple agencies. So these are the issues I think I was expecting to see, and you lending your voice towards it that, this is what I think it should be, So these are critical things. Yeah. So like I said, it was such a big topic, and honestly, you did well. I prefer it separate. And also, Dennis, please, I don't know, can we, as much as possible, have these slides to have a proper look at least 24 hours before, because it always comes like this one sneaked in 11:30 last night. So that we can have a good look, because most of the time I end up having a good look at it, or a partial good look at it when they're presenting. So if you could have it latest Thursday, so for at least 24 hours, I don't know if I'm talking about other mentors, so that we can have a good look and not just come up with our responses when we hear them talk, so that we can read it and have a good one. If possible, that would be a great one. So all in all, Ayobami and his team, good one. Like I said, it could be better, and but all the way. And of course, I need to my favorite reference in the talk I usually have is not there, and so let's always cultivate that, not for here alone, for your research works. And when you become a lawyer, you know that just like you mentioned digital precedents, you have to reference precedents, and that way it makes you a better lawyer. And also peradventure, if when you're published and there are new law and regulations that it is now in, down home reference, it's easier for us to point out that, we wrote this article, I referenced this article at a particular time. So now it has changed, So these things it brings clarity to your work and your research work, basically. All the same, good work. Yeah, thank you.
Thank you so much, Mr. Ayobami. I'm sorry about the lateness in which the presentations were sent. Well, I think mentees, we should also take cue from here, because majority of the presentations are not sent on time. I think Group 2 sent theirs very, very late. So that was the reason why we couldn't send them on time. So please, we'll also direct this observation to the mentees that next time when working on presentation, please try to adhere to the time given for the submission of the presentation. So thank you very much, Mr. Ayobami, for pointing that out. And we would like to have Ms. Obo, if she's still with us, also give her comments. Then we'll just take live questions and call it a wrap for today.
Okay. Hi. Thank you. So I just want to say a big thank you to the team. I felt the first presentation was very detailed, but this presentation, I think, was very clear. I liked, just like I spoke about, I liked the perspective, the fact that you were looking at, and it's like you created a new question, like a different interpretation from how I think myself and a couple of other people, how we took on the topic. Yes, it's a very wide topic, very broad, but I like the fact that you were able to create a narrative around the presentation you were going to make. I think it was very well done. I liked the presentation, although I was driving and I couldn't really see, but I was looking at it from time to time. So I would say very well done. Good job to the team. Keep it up. More work. Of course, the reward for good work or hard work is more work. So the feedback given by the initial my preceding mentor is also something you can take in your future presentations as well. In terms of the content, I also like the fact that you touched on statutory contracts, because I remember when we had that discussion with NUPRC and they kept saying, oh, it's a regulatory contract, it's a regulatory contract. It didn't go down well with a lot of people because we felt the entire objective, even though there are some elements, that are contractual, a contract must still, have commercial value. So when it's time for the regulator to concede on a particular issue, because they don't want to concede, they will just say, oh, it's a regulatory contract, and you can't really argue with that. But the value in having a regulatory contract, I think, goes to the root of the nature of energy contracts generally, because it's a contract that has such far-reaching effects. Really, everybody's using these utilities, whether it's water, whether it's power, which is what most of these energy contracts he was discussing pertain to. Those are contracts that affect national security, so you must comply, with the law, and they must have that contractual of no, so not contract, they must have that statutory or regulatory flavor. I also like the fact the part where you talked about compliance and you looked at case studies. I thought those were very interesting stories that we could go back to look at. I was also trying to look out for some Nigerian examples, or a lot more Nigerian examples, and examples that we could easily pick or relate with. I think that's one area we can also improve on future presentations. But other than that, and in addition to some of the comments the earlier mentors have made, I wouldn't want to repeat them, but I felt it was a very good presentation, honestly. I think it was very clear, and the presentation, the way the presentation was presented was very good. So very well done to the team. Very well done to the team. Thank you.
Thank you, Ms. Obo, for that comments, that wonderful comments and observation. Okay, so before we just take questions quickly, can we just have our picture time right now so that we can get that done with? So we would like to ask both our mentees and if our mentors too can also, in their own small way, just help us turn on their video camera so that we can have our picture time. All right, man. Can we have more mentees, please? More mentees, can we have you turn on your camera so that we can just take the picture? All right, thank you very much. Our mentors and our mentees that were able to turn on their videos. So I think we would just like to take maybe a question or two from our mentees so that we can have our mentors address it and we can call it a day on class. So are there questions from our mentees? Anything you would like to ask our mentors so that we can okay, CC, do you have a question? Or C rather? Are you with us? Do we have questions? Come on, please, let's ask questions. Okay, are there no questions at all? Okay, if there are no questions, okay. Okay, I can see one in the chat box. And it's from Amir. Okay, talking specifically about disputes in the sector, what can we do to help resolve such disputes as youths? Can we have Ms. Obo address this question?
Okay, are you looking at it from like a social angle? Like what youth can do to resolve legal disputes in the oil sector? Oh, okay. Okay, what's the place for youth? What's the place for youth in resolving oil and gas disputes? I think I'll look at it from like issues that sometimes we have with our host communities. Because as much as the law is like, oh, this is what you need to do for your host communities, even when you do or when you comply with the regulatory requirements for host communities development and all, you still have issues with maybe some youth group, raising concerns, and sometimes their concerns are valid because companies might say, oh, we're investing, for example, 100 million. Sorry, my background is noisy. Companies might say they're investing, for example, 100 million for community development. But in terms of the effect of that 100 million, it might end up entering the pockets of some chiefs, some other interest. And so when things like that happen, of course, the youths they are the appropriate sector, I would say, of the community to raise an alarm and to actually fight to ensure that community interests are actually catered for and not the interest of maybe the leaders or the chiefs in the community. So I think youths have a role to play in terms of advocacy. Youths have a role to play in terms of like early alarm. Do you get? So if there are issues that are going on in the community, it's better for those issues to be raised early on. I think one area where, in my experience, like youth from local communities miss it is when they are not organized. When they attune to violence and when they're not, let me just go when they're not organized. Because if Nigerian youth or youth in those communities organize and present their case properly, they get the right lawyers, they get the right advisors, they follow the legal procedure, you will give the oil companies a run for their money. But when
they are not organized. When they just react, they just go, they block, they stage maybe like a block out, block the entire access to the facility, or try to shut down operations, or go about, vandalizing. You're not organized. You will be met with the wrath of the law. But when you're organized, you look at the issues, you get proper counsel, get lawyers, get environmental NGOs to work with you, and you organize yourself and you present your case. I promise you, you will make the oil companies responsible. So that's one way I feel, that's one role they can play. So it would not be like your conventional dispute resolution, because your conventional dispute resolution mechanisms are, they are very structured. You can't say, oh, a youth has to be a mediator, or a youth has to be, those are other spaces that a youth might decide to play in, depending on their own career goals. But looking at collectively, what youth, the role the Nigerian youth can play in this energy disputes, I will look at it from like the community angle, and how they can be better organized in presenting some of these disputes so that they can actually have them resolved. I don't know if that answers the question, but that's how any other mentor may want to add on. Yeah.
All right, thank you, Ms. Obo, for that contribution, or that answer rather, to that question. Okay, we'll be taking the last question for today, and the question is: what are the most common types of disputes or conflicts that arise in the energy sector? Can we have Mr. Ayobami, if he's still with us, help us with that question, sir?
Yes. One of the most common that I have seen, so I'm talking my personal experience, will usually be non-performance. I noticed that since Nigeria were a consuming nation, for example, so sometimes you have to bring in a lot of equipments, and from outside Nigeria. There's always timeline issues, and also scope of work not clear enough. This is what the company wants. Contractor thinks is something different, and that's why I usually call for a responsibility matrix in every contract. Let everybody know that provision of water, for example, is for this person. Provision of security, healthcare, as little as that. Having a responsibility matrix, and everybody knows where the responsibility starts and ends. So it's usually on non-performance. Usually, I mean, I've been in a arbitration, a mediation on that. It was one party had a $19 million claim, and then the video was settled for $2.5 million. But I mean, so it's usually based on like earlier, I mean, Anthony is saying, it's very important that we have scope of work and responsibility metrics very clear to avoid dispute resolution. Thank you.
Thank you so much, sir, for that. Okay, we would have loved to take more questions, but we're so short on time, and another class is about to start. So we want to say thank you to our mentors for joining us on call. Thank you to Mr. Ayobami. Thank you to Ms. Obo. Thank you also to Mr. Okeogene and Mr. Alexander in Essential. So we want to say we really look forward to having you in all subsequent quarters. Thank you for sharing your knowledge and experience with us. I'm sure we have learned a lot on this topic, though it is very vast, and though covering it may take a lot, but in your own small ways, you have settled down to help us tackle issues that regards this particular topic. We also want to say thank you. I also want to say thank you to the mentees for being available on call. Thank you for joining in. I'll be sending some messages to you people after the class. So well done once again, and I wish everyone the rest of the day, to enjoy the rest of the day rather. So bye everyone. Take care, everyone.
Bye. Thank you, everyone. Enjoy. Bye-bye.
All right, ma.